Hi everybody, I'm Brian Tuck. Welcome back to Tuck's Rules. This week we talk about a really important U.S. Supreme Court case that came down Tuesday of this week, which potentially affects every employer and every employee that is not in a union, which represents about 90% of the U.S. workforce. Let's get into it, shall we? In this case, there were three separate matters that were consolidated, one being Epic Systems Corporation versus Lewis, the second being Ernst & Young versus Stephen Morris, and the third being the National Labor Relations Board versus Murphy Oil USA. All three cases presented the same legal issue. Justice Gorsuch delivered the opinion of the court and framed the questions in this way. Should employees and employers be allowed to agree that any disputes between them will be resolved through one-on-one arbitration? Or should employees always be permitted to bring their claims in class or collective actions, no matter what they agreed with their employers? The Epic Systems case really is about power in the workplace. It's about the difference in power between employers and non-unionized employees. The issue in this case was whether an employment agreement which waived the employee's right to bring a class action for employment-related claims was enforceable. The plaintiffs in the underlying cases were all non-unionized employees. They cited the Fair Labor Standards Act, which is the federal employment legislation which creates the right for workers to collectively unionize, to collectively bargain for themselves, etc. But again, in the cases that the Supreme Court just looked at, none of the underlying employees were unionized. The court looked at the plain language of the agreement and interpreted the agreements as they were written. The holding of this case is that employment agreements, when you're in a non-union setting, can require employees to waive class action status for employment claims. This case broke down along ideological lines, not surprisingly. And again, in the spirit of Tuck's Rules here, we're not talking politics. We're just reporting the facts. It was a 5-4 decision with Justice Gorsuch delivering the opinion for the majority. In the majority on this case were Justices Kennedy, Alito, Thomas, and Roberts. In the dissent was Justice Ginsburg, Breyer, Sotomayor, and Kagan. So what are the key takeaways from this case? They're pretty simple. For employers, the key takeaway is that employers should now review their employment contracts that they use with their workforce to examine whether or not they want that class action waiver in there. For employees, the key takeaway is that you should carefully read every employment contract you ever sign. You cannot sign the deal and then worry about it later. You have to negotiate the terms up front. The third key takeaway from a public policy standpoint is that the National Labor Relations Act is still alive and well. Workers can still form unions. Workers can still collectively bargain. But in a non-unionized workforce, contractual rights can and do control. I hope you found this video helpful. If you did, please subscribe to the channel here and share with a friend who you think this may be of help to. And I will see you next week. Be good. If you're interested in building your business from square one to viability, check out my first book, Risk, Create, Change, a Survival Guide for Startups and Creators, which is now available on Kindle and in paperback on Amazon.com.